Welcome. We're back again talking about another litigation victory with Tall Golden, our advocacy director. Welcome.
Hi.
Thanks for being here. And so let's just jump right into it. What is this case all about?
Yeah. So HB 393, HB stands for House Bill 393, was a law that the legislature passed in 2023. And effectively what it did was set up what's called an educational savings account for students who are students with disabilities to spend public money on educational services, which were broadly defined, and we'll get into that in a little bit. And the concern that we had is the way that it was funded. The way that these educational savings accounts were funded. What they did, how they work, is that a school district receives money from taxpayers, and it's a combination of state money, state tax dollars, and local tax dollars. Local tax dollars are generated by levies. So when you go and you have a school board election, right, you get to vote. The people who live in that district get to vote and decide how they want their tax dollars spent. What this bill did was after that money is paid into the district's coffers, into the general fund of the district, it took that money out, pulled it back up to the state, and then took a 5% cut off the top to fund OPI's administration of this grant, of this ESA program, of this so-called savings account. And then 95% of that money was available to this individual student to use for all kinds of things. And when I say all kinds of things, there was a big catch-all in the law that said any other expense that the superintendent of public instruction approves. So literally it could have been almost anything that could conceivably be connected to education. And as an example, one actual student was approved to use the money for circus school.
There is a school for circuses. Where's the school for
I don't know where the school for circuses. I know that there is a school for circuses because when I was a kid, I had a friend who went to circus school.
All right,
but he didn't do it with public money.
Sure. Yeah. So, all right. There's a lot, like any law that's passed, there's a lot in there. So we start with education savings accounts. That sounds to me, just those words, education savings account, that sounds good. Savings accounts are good. Education's good. A savings account that helps you pay for education, that sounds like lots of parents, grandparents, they might put money away for their kids' college. All that sounds pretty good. Why can you just get to why would a disability rights group like us want to sue the state for having savings accounts for students with disabilities to pay for their education needs? I think that's what folks who are maybe not as close to it as you and I have a hard time wrapping their head around.
Yeah, and I'm glad you're asking those questions because it was actually called the Students with Special Needs Education Savings Accounts, right? And that question came up. Why would a disability rights organization not want this? A couple of things. One, about 90% of students with disabilities get their education from the public school, from the traditional public school. And because this money is extracted from the public school, and public schools operate on economies of scale, there is less resources available for the 90% of kids who rely on the public school to receive special education and related services under the federal law, the Individuals with Disabilities Education Act. And you have to think about Montana has almost 400 school districts. In a state of 1 million people, that's a lot of school districts. Some of these,
And I mean, they're not all the same. I mean, just like not all our towns are the same. You've got school districts like down in the Bozeman area, Gallatin area, that have a lot of money because earlier you were talking about you can raise local tax dollars to pay for things at school. And then you've got the rest of the state that can be very rural, doesn't have as big a tax base. So, yeah, 1 million people divided up in 400 small little pockets, and those pockets are not equal.
that's correct. And some of them are very small. There is a district, there's more than one district that I know about that the entire K through 12, right, all years, is no more than about 30 kids.
Wow.
There are literally one-room schoolhouses in Montana. So those districts, when they lose the money associated with even one student, that's not something that they can absorb easily. But then you have to get into like how the mechanism of school payment works. And we don't have the time to go into all school funding in Montana, which is very complex. But the idea that people need to understand is that how much of that state money is transferred to a school district every year is dependent upon a count of the number of kids that were in the school district the previous year. And it's counted on 2 days in the year, one in the fall and one in the spring. And the state uses this phrase, average number belonging. So it's an average number of kids that were in the school, literally attending on that particular day, those 2 days. So
Right. I know as a parent, I've gotten emails from the school saying, make sure your kids are showing up because we're going to have to make a count pretty soon. And so, if you're out for vacation or sick or you haven't moved to that district yet, you may be there the rest of the year, but they're not getting paid for you.
that's correct. If it happened that there was a virus that went around and a bunch of kids were sick on one of those 2 days, that would impact the average. So the school would literally get less money the next year. But here's one of the really tricky things about this bill. It allowed students who had never actually attended that school district to still receive that money. And so if you think about it, a kid who for the first time is attending kindergarten is eligible for this program if they have a qualifying disability. They never attended the school. So in year one of their participation, that school district has to pay out, and it's estimated around between $5,000 and $7,000 into that student's individual ESA, Education Savings Account, but that school district has received $0 for that kid because they never attended the school. Another group of kids who could have participated in this program are kids who transferred from out of state. Again, never attended their local school district. That school district didn't receive $1 for that student because they never were counted. And then in the first year of participation, they have to pay out for that kid. For high school kids, it's even more. It can be almost $9,000. It goes up every year, and it depends on a bunch of different factors. But that's $9,000 that revenue was not received for that student, and the district has to pay them out. A third group of students that emphasizes, I think, our concerns about this law are kids who are fractionally and partially enrolled. So Montana allows kids to be homeschooled and still receive some services from the district. Sometimes that's just participation in school sports. And that kid is considered fractionally enrolled, and the district gets a little bit of money for that kid. Sometimes if they're just participating in like a high school sports program, it's a couple $100, and then they have to pay out almost $9,000 for that kid. So who's covering that loss, right? That loss comes from other services and programs, or from cutting services and programs, cutting for services and programs for students with disabilities, which is one of the first places schools look because that's the most expensive group of students being served. And it also comes from cutting other programs like STEM programs, like technical education programs, sometimes sports programs. So we're looking at 90% of the kids that we serve that are getting their education from public schools and getting those services that federal law allows them to have for special education services, now having less resources, paying for kids who never attended the school in the first place.
All right. Wow, that's really starting to come together as far as like the counting and then who actually attended and who's pulling money out. It sounds like the base education funding scheme is very complicated. And then it sounds like this is yet an added complication on top of that, that when it plays out would hurt those students if, you can't buy 2/3 of a special education teacher. You have one or you don't have one.
That's right.
And so you take a student or two out, that's maybe $18,000 out of a small school. You said some schools only have 30 people K through 12. And I know there are creative, also complicated structures where different school districts share access to specialized services and things like that. And we have some videos coming out about some of that type of stuff. Needless to say, this is really complicated. And the people who put it together deal with this complication all the time. So they're the ones who made the first bit complicated and added the second complicated bit. Can you talk a little bit about where the idea came from? You said House bill, so it came from the House. The House is part of the legislature, the state legislature here in Helena. Was this totally unknown? Like it just crept up on us that this might be a problem, or did we know this was going to be a problem coming down the tracks?
Well, this has been a national movement, right? So a lot of people here have probably heard about school vouchers. This program is a school voucher by another name.
Okay.
School vouchers generally are very unpopular, so the proponents of vouchers are starting to call them different things and
Like
try to
education
achieve.
savings account, like I was saying, that sounds good.
Right, right.
Yeah.
And when you put the word special needs in front of it, then it's really hard to oppose.
Right. Who wants to be against kids with disabilities? I mean, lots of people. That's what this whole podcast is about. But let's go on.
But in reality, it's a voucher program by a different name. And so that's been moving around for 30 plus years.
Okay.
What is the base idea of that is on one piece is there a way to provide more choice to parents and students? If the traditional public school doesn't work for them for some reason, are there other models that we can incentivize? And the concern generally with these types of programs and vouchers is they don't open the door to everyone. So I'm not aware of a single instance anywhere in the country of any voucher program in the last 30 years that has ever covered the entire cost of attendance at a private school. It supplements the cost of a private school, but anyone who's out there who's looked at private schools, some of these cost what a college education at an Ivy League school costs, $30,000 to $50,000 a year. And you're getting a voucher that covers $7,000. What that does is provide a subsidy to very wealthy people who could afford to send their kids to private school anyway. And
right.
now,
If they could already afford $24,000, they could afford $31,000.
Correct.
Example. Yeah.
But the person who's even middle income doesn't have that option. And so now they're left in a public school with even less resources to serve them, while their tax dollars are being used to subsidize somebody else's private education.
And you put a lot out there. Also, the fact that you haven't seen that's not just sort of some random lawyer in Montana hasn't seen that. You're on National Board for Education Law. You are on the National Disability Rights Network's legal committee. Like, you look at these issues pretty regularly on a national scale and how they affect Montana. But when the concern, just like education savings account sounds like a good idea, just having an ability to save for education sounds good. Being critical of the services that are delivered to students with disabilities is not unreasonable either. Saying, a parent might be dissatisfied with what services their kid's getting. We hear about that. I mean, that's a lot of what we do, is help people figure out how to advocate for appropriate services, because people aren't getting those in school all the time. But this, again, I guess maybe it goes back to that packaging around the education savings account sounds better than saying this is a voucher, and saying this is fixing a problem around inadequate special education services sounds, well, who can be against fixing that and giving people better choices for accessing better services? But the specialized services and the specialized instruction that a student with a disability will need will cost more than your average tuition at your average
Yes, I mean, that's
school.
true. And as you know, a lot of my practice over the last decade has been representing students with disabilities in public school. And so I've had the opportunity to have to investigate private schools for students with disabilities, and those can be close to $500,000 a year. Right.
So 9,000 isn't doing much. No, but it does impact that local small school. Hey, this is a perfect time to subscribe to the podcast. Just click below and you'll get notified when we have new updates. And of course, share with your friends, text them, social, however you can get the word out. And you can also subscribe to our Substack. That's where you'll get more material, go deeper dives, written and additional video and audio will be displayed there. So please join the Growth Rings family. Subscribe here and subscribe on Substack. Thanks. All right, so we've got these complicated laws, complicated funding streams. How do you go out and connect with the community to learn what they want? Should we be bringing this lawsuit? I mean, the factual side, I know the factual side of building a lawsuit takes a long time. It can be really difficult to find people who both understand the issue deeply enough to want to sue about it, but also have the emotional and mental bandwidth to take on thinking about this really complicated area of law with really complicated funding streams. How does that work in this area?
Yeah, so I think with all of our work, we start with where's the community at that we serve? And because we have been doing education work for decades, we're well known for that. We get a lot of calls about education cases, and we're speaking to parents all the time about students with disabilities in K-12 schools. So we start by talking to the community and seeing where they're at, what their interest is in a piece of legislation. And that's true across the type of legislation that we work on, not just in schools. There are times when a law comes through the legislature and we can see different sides of it, how the disability community may be impacted by it. So we'll go out and talk to the community. And sometimes it's true that we'll hear from our constituents some support and some oppose a bill. And in that case, we may sit out of it. We might not take a position on it in the legislature because we don't have a consensus from the community about what their perspective is. On this case, it was very clear that we were taking public money from the many and subsidizing the few. And the many in Montana, there is so little private schooling that almost all kids, 90% plus of kids, get their education from the public schools. So it wasn't a real complex choice there, but we were talking to parents and hearing from parents that, one, there's no private school where I live anyway, so there's not going to be any benefit for me. Mm-hmm. And two, the amount of money that's available from this program for an education savings account would not even begin to cover the needs that my student has, that they're allowed to get and required to get for free from their local public school. And so for that reason, the parents were telling us, no, I don't support this bill, and it wouldn't have any impact, and it would have a detrimental impact on my student and other students.
Yeah, I kind of think about like if my car breaks down and it's not working well, selling it on the cheap for like $1,000 and then going to buy another car that's really expensive doesn't really make sense if I gotta fix it. I have to invest a little bit more into it. Yes, our local schools, do they need to do better around education of students with disabilities? Sure, but let's try to fix them up, not sell your rights down the river really cheap and then think that with your $7,000 you're going to go be able to buy some new education somewhere else that's going to meet all those needs without the legal protections requiring that it meet all your needs. It doesn't make a lot of sense. So it sounds like here it was clear our community needed it, which then makes a lot of sense why we joined as an organization on behalf of the people with disabilities in Montana who'd be impacted by this. Can you talk a little bit about our standing? Standing's a legal word that just means you have the right to sue somebody. You can't just sue somebody because you don't like the haircut. There has to be some sort of legal issue, and you have to be the one impacted by it. You can't say, I don't like how my sister's boyfriend treats her, so I'm going to sue on her behalf. She's got to be the one suing. So can you talk about that?
Sure. And without giving you a law school course on standing, it's the right to sue. And it centers around the idea that if you're going to bring a lawsuit, you have to be personally impacted in some way by the issues in the lawsuit. And so organizations to sue have to have standing too. And protection and advocacy systems like we are, the courts have found again and again that we can bring cases in two ways, in two types of standing. One is because it harms our mission, the issues in the lawsuit, and two, because it harms our constituents. And one of the ways that the courts have gotten there is because Congress created this system very specifically to protect and advocate for the rights of people with disabilities. And it's clear Congress's intent was that we should be able to sue. It actually says that in the laws that authorize us, is that we are required to have the ability to sue on behalf of people with disabilities to protect their rights. So that's how we have standing. There is another group, our co-plaintiffs, called the Montana Quality Education Coalition, which is a group of groups. It's a group of organizations that represent the interests of public schools, from school boards to superintendents to special education administrators. And they have this coalition that serves as a gathering place for their collective interests and works on their behalf in the legislature and enforcing the rights of public school students. So we are co-plaintiffs in this case with the MQEC. I think it's important that we have that coalition. It's really interesting because a lot of times we're opposed to public schools. We sue public schools
Sure.
When they're not complying with the law. But here we found common ground. This law impacted students with disabilities and students in general in a way that we both saw was harmful to public schools and public school students. And so we got together in this case. We hired a law firm called Upper 7 Law, which worked with me as co-counsel in the case. Upper 7 works on enforcing the Montana Constitution and government accountability issues, and they're an excellent law firm.
That's an important thing to know. We can't possibly do all of the work that is necessary, or even all the work that we're able to get to among all that is necessary, without strong partners. And that's strong partners in policy advocacy and in being co-plaintiffs, but also lawyers. So if you're a lawyer out there and you're watching this because you're a nerdy lawyer and you want to know the ins and outs of this complicated funding and legal case, great. Love to have you here. But you can also work with us. If you have a passion of you have ADHD and you want to work on ADHD issues, or you have a physical disability and you want to work on accessibility in government buildings, call me up. And we can talk about how we might be able to best partner. And if you're not a lawyer, but you have a deep passion about things, we also have a coalition that we're building of regular Montanans across the state who want to embrace their knowledge and power as disabled advocates. It's called the Collective Disruption. I'll put a link to that below, and you can sign up for that. We're holding our first meet and greet very soon, and after that we'll continue to hold meet and greets, and because it's always good to celebrate with each other, but also some trainings on how to do advocacy and start to strategize about different advocacy campaigns we can engage in. So you got your team together, both the people who are the right people to sue and the lawyers who are the right lawyers to bring this. You wouldn't just have any lawyer do this. Again, it's a complicated legal area, complicated financial area. It's great we got the right team together here. Now, what did we do with that team?
Yeah, so we got together. The lawyers have a lot of strategic discussions about the law and the legal theories. In this case, the group that Upper 7 was representing have a lot of constituents within that group, so they've got a lot of differing interests that they had to work through to make sure that the positions that we were taking in the lawsuit met everyone's needs. So that was a process. That takes some time of doing the initial legal research, starting to formulate the ideas about why this law is unconstitutional under the Montana Constitution. What is it that we want from the court? What are the remedies that we want? What do we want the court to do? And putting that all together into a complaint, which is setting out, here are what the facts are that we think are true. Here are the legal claims that we have. In this case, this is how this law violates the Montana Constitution. And here's what we are asking for the court to do about it.
I think that's a really important thing to point out, that you had to do legal research to find out why it violated the Constitution. I think so often, if you're not a lawyer, you see law like in TV shows and you think, okay, so if someone punches someone in the face, they get arrested for assault, and then you try that case. That's pretty straightforward and specific. But if there weren't a law that said you can't punch people in the face, or it wasn't so explicit about that type of harm, you would still feel like I shouldn't be punched in the face. If someone punches you in the face, you're like, I don't like that. That shouldn't be happening. Then you'd have to go, well, do we have any rules against that? Or can people just do that? And when you get to complicated areas of education law, complicated areas of state constitutional law, we don't have, as a society, nearly as much practice thinking about those as we do don't punch me in the face. It's more abstract. And so it takes some time to, okay, I've got this gut feeling that this isn't right. You're taking money from 90% and giving it to the 10%. There's something that doesn't sound right. Now, just because it doesn't sound right, just because it sounds like it might be immoral or illegal, doesn't mean it actually is illegal. It might just be immoral. There are plenty of things that are immoral that aren't illegal. So you all had to spend time doing sort of the rudimentary job of legal research and writing. Just sit down, read laws, read the cases about those laws, see how similar they are to this fact pattern, and then write up your thoughts about how this case is a little like that and that case is a little. So we can have a whole podcast just breaking down what does that look like, how to think like a lawyer. But on these types of cases, like state constitutional laws or big systemic education cases, they often are cases of first impression, as we say.
That's
Like
right.
there hasn't been a case exactly like this before. There have been plenty of cases of don't punch people in the face. There are not many cases. There were no cases in Montana about can you have an education savings account that takes the money, the state money, out of the local school and gives it to parents via the Office of Public Instruction to spend on things related to their kids' education. That's a very novel approach, and therefore no laws and no courts have addressed it specifically.
Yeah, one thing I'd say about that is I think it really underscores the importance of nonprofit public interest law firms like we are, like our friends at Upper Seven are. Testing a case like this, where you're dealing with new issues of constitutional law that haven't been ruled on by the courts in the past, is a very expensive proposition, right? We have an obligation as lawyers to carefully research the law and to make sure that our arguments that we're making to the court and the factual claims that we're making are well grounded, are well researched, and besides that ethical obligation, as a practical obligation, we want to make sure that we're bringing strong cases that are well reasoned. That's an expensive proposition. And it's a process of protecting public interest that doesn't really make sense for a private law firm to engage in. A private person couldn't possibly pay for,
Sure. Yeah.
right, by the hour, the work that we would have to do and the number of hours we've put in to bring a case like this. And so it is really important, for folks who are listening to make sure that you're supporting organizations like us that are working to protect the public interest. Because if we're not doing it, particularly in the disability space in Montana, there's no other law firm out there that's doing it, right?
Right.
There's no one protecting those interests.
And that's one thing that, as Tall and I talk about being good stewards of the resources we have, we're not going to bring cases we think are bad cases. There's plenty of bad stuff happening to people with disabilities out there. So but the cases we do bring are the ones that the private lawyers can't bring. And so it is this middle ground of there is risk in that no one's ever done it before, but it needs to be done. And there is a good, strong case there. So let's do it. So we brought the case, we got the team together, we did the research, we filed the complaint, and we can kind of fast forward a little bit. There's some, like I had to testify. You had to examine me in court. I haven't been on the witness stand myself in a very long time. We can talk about the time before that I was on the witness stand. That's a more interesting story than this one. But we wrote about why we thought it was unconstitutional, the law. We gave testimony. There were experts that testified. And this week, the court came out with its decision. It weighed all of that. And what did it say?
Yeah, and I don't know if we talked about the preliminary injunction part of that.
Oh, no, we can talk a little bit about, the early days in the case setting this up. Yeah.
Yeah. So in a constitutional case like this, and it can happen in other types of cases, it's common to ask the court for an order called a preliminary injunction. An injunction is an order directing a party, in this case the government, to do or not do something. In this case would be stop enforcing this law. It's unconstitutional. And a preliminary injunction is a motion you make early in the case saying, we think we're going to win this case. We think that if you don't stop the bad thing that's happening now, while the case is being litigated, irreparable harm is going to happen. It's in the public interest to pause the bad thing that's happening now. And when you look at the parties' respective rights, the balance of those rights tips in our favor. And so one way that I often explain it is in environmental cases. It's sort of easy to understand. If you think about, a bad corporation that's dumping toxic sludge into the Clark Fork River, and you're suing that organization saying that violates environmental laws, you can't wait the 3 or 4 years it's going to take to litigate that case to stop that bad action, because the court's never going to be able to pull that toxic sludge out of the Clark Fork River. So you go to the court and you ask for a preliminary injunction, and sometimes even an emergency order called a temporary restraining order, to stop the bad action immediately because of that irreparable harm, because it can't be undone. So we went to the court and we didn't ask for an emergency order, but we did ask for a preliminary injunction saying stop it during the course of the case. The court didn't find in our favor in that case because the court didn't think that there was irreparable harm, because it was very early. The program hadn't really been implemented yet, so there wasn't enough evidence to show that there was a large group of people that were participating, and it was going to have a very large fiscal impact.
And money's hard to show it's irreparable anyways, because it's
right.
like, okay, you took money from me last month, give it back now. The money's the money.
Right.
Versus the sludge, you can't undo that.
Right,
Yeah.
right. So that part of the case was done, and that means very little in the grand scheme of things, except that we have to proceed with the rest of the case.
Right, right. It's a useful thing for the judge. If the judge weighs in at that point and gives the order, it's useful for negotiations to say, well, the judge already thinks we're going to win and has already stopped you from doing it. So can we just come up with a better solution that can meet our needs, or do we need to go all the way to trial and let the court continue to make decisions for you? And usually defendants don't like the court making decisions for them, and they'd prefer to negotiate something that works better for them than leaving it up to the judge.
That's right, yeah. And of course, where that irreparable harm piece is there, then preliminary injunctions and temporary restraining orders become very important.
Yeah.
But in this case, it was really a constitutional violation that hurt the people of Montana globally, but it wasn't causing daily harm to a specific individual.
Yeah.
So different type of case. So from there, we go forward in the case. The case is on a pathway to trial. And the law creates a lot of off-ramps for trial. Trials are very expensive for everybody, for the courts, for the litigants. Again,
defendants don't like courts making decisions for them. Plaintiffs don't either. I'd prefer to come up with something more nuanced. Judges are just a person. So, and they only have so many tools at their disposal. Whereas when you negotiate, you've got almost infinite number of tools available to you.
That's right. And so the law creates a lot of off-ramps to try to avoid a trial and make decisions on the case and finally resolve a case before trial. And in constitutional cases like this, often the questions the court needs to decide are questions of law, not questions of fact. And so questions of fact, often they go to a jury. A jury gets to hear the evidence and say, oh, here's a car accident case. Was the light green or was the light red? And we hear all the evidence, and the jury makes a decision what's true and what's not true. But in constitutional cases, often the facts aren't disputed, right? Everybody knows this law was passed.
Yep.
Nobody disputes that. The question is the law constitutional or not? So the law provides a mechanism called a summary judgment. And as the name sort of suggests, it's a way of reaching a judgment quickly when there aren't questions of fact that need to be decided in a trial. The purpose of a trial is to decide what the facts are. So in this case, we both parties moved for summary judgment, and that happens. Sometimes they say, "Oh, yeah, there's no dispute of facts, but we think the law is this way," and the other party says, "Yep, there's no disputed facts, but we think the law is this way." And that's what happened in this case.
And much better than us banging our heads against each other. Let's go to a judge. Judges are the ones who decide what the law is. So go, judge, this is our argument, and they'll say their argument, and you decide what does the law actually mean in this case?
Right. So that's what we did in this case. We filed a motion for summary judgment, and there were multiple claims in the complaint, various areas of the Montana Constitution that we said were violated by this law, both in terms of how the law was passed and in terms of substantive protections that the people of Montana have under the 1970s Montana Constitution. And there's an opportunity to brief that, right? Both parties get to make their arguments in writing to the court. And then the court, in this case, had an oral argument where the lawyers get to discuss their positions. The judge gets to ask questions. And then the judge takes the case back and thinks about it and researches for himself and writes an opinion. And that takes many months to get through. And Judge Manahan did that. And earlier this week, Judge Manahan issued his ruling, his order on the motions for summary judgment.
And so, what did he order? What did he say? Is this a constitutional law or an unconstitutional law?
Yeah, so we alleged several ways where we think the Constitution was violated. The Montana Constitution is a really interesting document, and it protects the public in a lot of ways. And again, it was drafted in the early 70s, and it responds to an interesting history in Montana.
I mean, 1970s, not 1870s. So these people lived like us, not in horse-drawn cars and whatnot. It's whereas like a lot of states and the U.S. Constitution, written by people who, other than their humanity, don't have a lot in common with us day to day.
That's right. And so it's really interesting because it's reflecting on, 200 years of history under the U.S. Constitution, but Montana's Constitution, Montana's history of the copper barons and government corruption, and then responding to the civil rights era and the increased liberty and equality that people are starting to move towards. And so Montana Constitution just has some really interesting provisions that are protective of the rights of taxpayers and the rights of citizens. So there's multiple ways where we said, this law violates the Constitution. One of those interesting, important provisions is Title 10 of the Constitution that requires educational equity. It provides a right to an education, a quality education. And that's unique in and of itself. The federal Constitution doesn't guarantee a right to education. Not every state has that right. But one of the rights that, might seem boring to the average person, but it's important, is that the government can't spend public money unless the legislature makes a proper appropriation, a proper allocation of that money, and an authorization for the executive branch, for the government, to spend that money. And that was one of the claims here. Because of the way this bill worked, it created this open-ended system where an unknown amount of funds could be withdrawn from local government money, from public school money, sent up to the state. A 5% cut comes off to fund OPI, and 95% gets sent to private accounts. And one of the things that Judge Manahan ruled was that the legislature didn't follow the right process to specifically allocate an appropriation for that money. And that violates the appropriations clause of the Montana Constitution.
And so that brings us full circle back to this incredibly complicated finance system generally for schools, and then this complicated overlay on top of that to pull some of that money back out and give it to private individuals to spend on a variety of different things. That this complication on top of complication on top of complication, it ends up being the weight that makes the whole system crumble, in that they could have just simply said, we want to create savings accounts, here's $70,000 to put into some savings accounts, go at it.
Yeah, I think that's so interesting because the law gets invalidated on this important piece of financial regulation. But it goes back to a policy piece.
Yeah.
It goes back to we can experiment with different ways to provide education. The legislature has that power to create social experiments and pilot projects and try to see, is there a better way to educate people with disabilities or students in general other than the traditional public school? But the legislature has to make it, in my view, and this is one of the things we testified on, if you're going to have an experiment, a social experiment like that, it's got to be a fair experiment. You can't put your thumb on one side of the scale. And what this law did was exactly that, right? It says we're going to take money from the public schools and we're going to put it in these private programs, and let's see if the kids in the private program do better.
Right.
While the kids in the public program have less money, and they were already under-resourced in the first place. Right? Montana public schools and most public schools never were adequately funded. And Montana's general school finance program system has always been broken. It's been litigated again and again. So it never fairly funded.
And if you really, I mean, I'm not being flippant here, but if the private education generally would cost $40,000 and you're getting $7,000 out of it, what would it look like if you invested $32,000, $33,000 into a student who is still going to the public school, and how much better could they do with all that tutoring and programming and support around them? Again, experiments have controls. They have processes by which you make sure you're measuring the right thing. And here, it did really seem like it was not even a genuine experiment, but rather we want to create a system that pulls money out of local schools and gives it to other innovative things. But that isn't comparing apples to oranges, and it isn't an appropriate way to fund to make an appropriation around this education program.
No, and I think that's a fair interpretation for a bunch of reasons. First, the legislature is perfectly competent to make appropriations, and that's one of the things that Judge Manahan said. They know how to make an appropriation, and in part of the bill, they did make an appropriation to fund OPI to administer this program. They make appropriations all the time. That's a huge part of the responsibility of a legislature. They could have added new money.
Yeah.
And said, we want the social experiment. We want to fund it as a pilot project. We're going to appropriate X number of dollars to do that. We're not going to take any money from the public schools.
Right.
Now, some public schools advocates would say, but you're still not adequately funding public schools, so it's still not a fair experiment, and that's a fair argument.
Sure.
But they didn't do that.
And this lawsuit wouldn't exist had that been the structure. It wouldn't. There might have been a different problem, but this particular problem that the court ruled the law unconstitutional about wouldn't be there.
That particular problem wouldn't be there. I mean, people may have opposed it politically or from a policy perspective, excuse me, but that particular problem would not have existed. Now, going back to that what you just said, when you look at this bill, there are no performance metrics. There is no funding for an independent university researcher to evaluate the program effectiveness. There is no reporting requirement, as many other pilot programs have, to come back to the legislature and report on success. And that's one of the things that I think underscore what you said, which is, if this was really a social experiment, where is the data and where is the data analysis, and how are we going to learn whether this experiment did or did not work?
Yep. So, well, now we know it didn't work legally this time around. The legislature can try other things going forward, but this particular law, the court said, is unconstitutional. Now, he ruled on this aspect as unconstitutional. Um, I I get why he didn't rule on another one of our arguments, but can you sort of try and break that down? Why a judge would, once the horse is dead, you don't need to keep shooting it. So found that one of our claims is moot, and the other one, there are some factual issues that you could argue about if you want to, folks, but it is unconstitutional for the purposes of an appropriation.
Yeah, so in a constitutional case, it's a little different than other kinds of cases because if a law is unconstitutional on any grounds, it's dead.
Yeah.
You can't continue to enforce it. So he didn't need to reach all of the other issues. There is one claim where he said there is a genuine issue of material fact, which just means that it's not appropriate for summary judgment. As I said earlier, if there are fact questions, that has to go to the court, to the jury, or to the court to decide those fact questions in a trial. So you don't rule on that at the summary judgment stage. So that one he set aside, but it doesn't really matter because he determined the law was unconstitutional on one ground, and that stops the law in its tracks. In a different type of case, you could have a partial ruling on one of the claims and say, okay, you've won on that claim, you haven't won on these other claims. Those things either are dead or have to go to trial.
Yep.
But because this is a constitutional case, we don't need to go to trial. The law is unconstitutional on one ground.
Yeah. This is reminiscent of many legislative advocacy positions or proposals that I've seen over the years where there's a desire to accomplish something, and by hell or high water, we're going to get it done, and forgetting some of those fundamentals but there are particular rules on how things need to play out, and you can't get too creative. You can't stretch the process too much because there will be a court who will eventually oversee this and see, did you break the rules in getting to where you wanted to get to?
Yeah, there's a lot to unpack there in terms of lessons learned and how to build policy that is sustainable over the long term. That's not going to end up in court and just have to come back and be reinvented the next session. I think one of the most important lessons learned is you have to bring the people to the table that are impacted by the legislation. And had they done that, had we had a series of discussions with legislators who were interested in advancing this social experiment about school choice and sit down with, particularly in this case where you're going to attempt the litmus test with people with disabilities, sit down with the disability community, sit down with the organizations that represent the disability community, sit down with the school boards and public school advocates and unions and all of the interest holders and say, how could we accomplish this in a way that meets all of these divergent interests? And maybe we would have come to something very rich that made a lot of sense, that protected varying interests. And what I always say in Montana is we're such a small state. We really could be a national leader in so many areas where we have the agility to try things in a state of 1 million plus people that would be so much harder to do in a state of 35 million people.
Yep.
But you've got to bring people to the table and have those conversations, and you can't do that in the confines of a 90-day legislative session where everybody's got their hair on fire.
Yep.
So I think that's one of the critical lessons learned. I hope. I think another critical lesson learned is if you don't do that process and you get into the 90-day session and you've got a bunch of lawyers telling you this law is probably unconstitutional, you probably need to pump the brakes and sit down and say, okay, well, how do we fix those problems? Because if you don't do that, the case ends up in court and the taxpayers foot the bill for that, right?
Yeah.
there was a team of lawyers on the other side that are paid by the taxpayers. That's expensive. The court is paid by the taxpayers. And if the defendants end up having to pay attorney's fees for the other side, the taxpayers pay for that.
The fact that Montana is as small as it is from a population standpoint also goes to the point of your legislators are really accessible. So
Yes.
If you're watching this, you are a disability policy nerd, you are in it, then we can put you in touch with the legislators who are interested in it. And there are many legislators, many legislative committees that meet regularly now in between the sessions every other year, that they are working on all sorts of issues. There's an education subcommittee, there's a healthcare subcommittees. They're looking at all sorts of issues. So if you are interested in those issues, leave a comment, follow that link that I'm going to put below about the collective disruption to get involved in these things, because your legislators, our legislators, are very accessible. In other states, they have like 2 or 3 paid staff per legislator that you've got to work through to get a 10-minute meeting, off of the session time, just to get a little bit of their time. Here, you can call them up and they will talk to you. They will read your email, because there are only a million people here. They're not being pulled around by, millions and millions of different people with all different agendas. If you're from their town, the population they're listening to is even smaller. If you're in their voting district, you are an outsized voice here. So please get engaged. Get engaged with us to tell us what we should be working on, what are the issues that are important to you, because as Tal was explaining, that impacts what we weigh in on in the legislature, how we get involved, whether we get involved in court cases. And as I said, you have an outsized voice with the legislature and with us, because we are just one big small town spread out over hundreds and hundreds of miles. So, and that is what we come up with here in Montana will be uniquely Montanan, because we have to design it for a state that has 400 different education districts, that has your grocery store may be 30 minutes, an hour away from where you live. We need to deal with those realities and be creative, but we can only leverage the knowledge of the people across Montana and the creativity that come from that knowledge if people are engaged. So let us know if you want to be a part of that group, the collective disruption that is getting together to disrupt the status quo and get people with disabilities in front of policymakers to design good policy so we can avoid messy lawsuits like this down the road. This is something we could have avoided had we done some different things earlier on. The legislature, listened to the lawyers, listened to the community, but know that we've got 3 branches of government, and Disability Rights Montana is here to do advocacy in all 3 of them. So if we can get what we need accomplished by talking to the administration, we will. If we can get it accomplished by talking to the legislature, we will. And if we can get it accomplished by talking to the courts, we will. Because our main goal is just to make sure Montana works for people with disabilities. So thank you again for joining us this week, and we'll see you next time.
Thanks, David.
Thanks.